Today I am going to deal with some of the very interesting and unique facts about one of the greatest and most landmark judgment of the Supreme Court of India in the matter of Kesavanda Bharti versus State of Kerala. The core question, apart from the validity of 24th, 25th, 26th and 29th constitutional amendment, was whether the Parliament has unlimited power to amend the Constitution or whether there are any implied restrictions on amending the Constitution. The 24th Amendment to the Constitution invalidated the landmark judgment of the Supreme Court given by a bench of 11 judges in the matter of I.C. Golaknath. The 25th Constitutional Amendment invalidated the landmark judgment of the Supreme Court in the matter of R.C. Cooper, also known as the bank nationalization case. The 26th Constitutional Amendment invalidated the landmark 11-judge bench decision of the Supreme Court. Privy Purse. The 29th Constitutional Amendment placed the Kerala Land Reforms Act of 1963 under the 9th schedule and therefore saving the said act despite the provisions of the said act being ultra-virus to the Constitution and having declared some of the provisions as being ultra-virus by the Supreme Court of India. Therefore, Kesavanda Bharti challenged the provisions of the Kerala Land Reform Act along with the constitutional amendment before the Honorable Supreme Court, wherein a 13-judge bench was constituted to decide one of the most important questions on constitutional law. There are several interesting, unique and unknown facts about this case. The judgment was delivered on 24th of April 1973 on the day of retirement of Chief Justice of India, Justice S. M. Sikri. It is the only case to be decided by the 13 judges of the Supreme Court of India. It is one of the largest bench who heard the longest hearing, which spanned for 68 days over 5 months, covering the widest areas of law and legal literature, resulting into a 703-page judgment with 11 scholarly opinions. The Supreme Court, by a razor-thin majority of 7:6, for the first time in any constitutional adjudication in the world, propounded the doctrine of basic structure, where the power of the Parliament to amend the Constitution was held to be not unlimited, and the Supreme Court held that the Parliament cannot amend the basic structure of the Constitution. Interestingly, there was no unanimity on what constituted the basic structure of the Constitution despite 11 opinions and despite the majority of 7 judges, who did hold that the power of the Parliament was not unlimited. The judgment was heavily criticized by the government as being ambiguous and incoherent and an attack on the supremacy of the Parliament. The judgment is considered the most remarkable in the development of the constitutional law as it saved democracy and prevented India from slipping into an authoritarian regime or a one-party government. Nani Palkiwala led the arguments for the petitioners and argued for 31 days. H.M. Sirvai argued for the state of Kerala and argued for 21 days, followed by Niran Dey, who was the then Attorney General of India. This case showcases the breathtaking scholarship of the 13 judges as well as the lawyers who represented both the sides. Analysis of the provisions of more than 71 constitutions of different countries were submitted by the councils. The theory of basic structure was not supported by any precedent or judgment of any court. The said theory was the brainchild of a German scholar, Professor Dietrich Conrad, who had propounded the theory of implied limitation based on the experience of Germany and the misuse of the Weimar Constitution by Adolf Hitler. Before the judgment, the basic feature theory was first introduced by Justice Mudholkar in his minority judgment in the matter of Sajjan Singh versus State of Rajasthan. He referred to the doctrine of essential features of the Constitution, which he derived from the Pakistan Supreme Court judgment in the matter of Fazlul Qadir Chaudhary versus Muhammad Abdul Haq. There are several unusual happenings in the matters which have been reported in various articles and books written by those who had first-hand experience of the matter. Justice Jagan Mohan Reddy, who was part of the 13-judge bench, in his autobiography, writes that I got the impression throughout that minds were closed and views were predetermined. He also mentions that the government was aware that the three most senior judges were against the government, and therefore on 25th April 1973 the government announced that Justice A. N. Ray had been appointed as the Chief Justice of India, superseding three senior-most judges, Justice Shelap, Justice Hegde and Justice Grover. Justice Khanna mentions about this supersession as a punishment or a show of government's displeasure at the judges not having toed the government's line in Keshavanand's decision. These are some of the interesting facts, unusual happenings, and unknown features of this judgment. I will be coming out with more such interesting and unknown facts, various judgments of the Supreme Court in my later videos. Thank you.